This is TWiT.
So let us move on to the drama that unfolded last week in the Waymo Uber case. This is the trade secrets case that has to do with secrets that were allegedly brought from Uber to Google by way of its Waymo arm. I have that right? It's secrets that went from Uber to Google and not the other way around? Mike, help me out here.
No, I think that
Do I have it
the
wrong?
claim is right. That
Yes.
Uber, or a company that was acquired by Uber, had taken trade secrets of Waymo, which is the self-driving car division of Alphabet.
Yes.
Google.
Yes. Okay. Thank you. We are now headed down the self-driving road in the right direction. Secrets alleged to have been appropriated by Uber when it hired Way.
I do want to point out, though, that that confusion that you had, Denise, I had it as well. And I just would like, as someone like, especially Matt, you can speak to having, in law school, you read a bunch of historical opinions and the language is very precise. And I think that may be a side effect of more casual speaking judges and attorneys and the language of the courtroom, because when it's reduced to a transcript, there's a lot of things like, you said this to you, right? Or it's just confusion about like, wait, who's saying what and where and what's going on? So
all right. So surprise, surprise. Uber is alleged to be the bad guy here, and it got worse last week. And the way in which it got worse is there are federal prosecutors actually looking at Uber's conduct here to see if federal criminal charges should be brought against Uber for its activity here. This is a civil case at the moment. And those federal prosecutors went to Judge Alsip, the judge in this case. Judge Alsip was also the judge in the Oracle versus Google case that we're going to talk about a little bit later too. And these federal prosecutors said, hey, we've got a letter. We're going to give it to you. We're not going to make it public. The judge has not made it public, but it had some information about Uber basically hiding the ball, not disclosing things that it knew or should have known or should have disclosed in the litigation. And so a firestorm that had nothing to do with the actual wildfires in California ensued in court last week as Judge Alsip tried to make sense of all of this. One of the fallouts of this is the case was scheduled to go to trial at the end of December. That has now been postponed until February. And in the meantime, when you read through the transcripts of the days of court proceedings on this, you can see that Judge Alsip is just at his wit's end in dealing with these parties and particularly Uber. The lawyers for Uber find themselves in the situation of having to say, hey, we didn't know any of this was going on. If it did happen, it wasn't our directions to our client, which is never a good position to be in as a lawyer when your client is accused of doing bad things. So the judge's patience is coming to an end, and the case is not coming to as rapid of an end because the judge went ahead and postponed things. Mike, you've probably been watching the procedural back and forth here more closely than I have. What would you add?
I have. I mean, this is like made for TV trial. Yeah. I mean, this is really something. I mean, I've never heard of a civil trial being postponed. I mean, the federal government, the Department of Justice swoops in, provides a sealed document to the court, and the court, decides to delay trial. I mean, they were set to go to trial, and literally this happened, I think, at the pretrial conference. And so now, as you mentioned, Denise, the trial is delayed until February. There's so much drama here associated with this secret shadow system that Uber allegedly had in place, and all of this encrypted messaging that went back and forth between Uber employees. So you've got that piece of drama, which is pretty heady stuff. Then you've got the whole issue about this letter from Rick Jacobs' lawyer, who is the former Uber employee, that had written a rather scathing letter about these Uber practices. Uber never turned that over in discovery. And of course, Waymo was going crazy saying that this letter should have been turned over to us months ago. You've got interesting drama associated with the search terms that the parties exchanged during the course of discovery.
That was my favorite.
Which is like, which is really
explain that in some detail, Mike, because I think people will just be blown away.
Yes. So how it works typically in any case of any size in federal court is the parties just don't turn over all their emails or electronic documents. Typically what happens is some sort of electronic discovery order is entered by the court, and the parties then agree to search their systems using search terms. And it can vary from case to case, but say in a typical case, or at least typical cases that I'm involved in, it could be anywhere between 10 to 20 different search terms. So we agree on search terms that we're all going to go back and search our client systems for. Well, apparently, this letter that's at issue didn't come up in Uber's search because it didn't have any of the search terms in it, and it came out in court that one of the search terms that or Waymo, I guess, neglected to have Waymo be a search term in the search terms that it gave to Uber, which I think a lot of people were scratching their head at. I mean, of course you would want to have the name of your company, Waymo, in the search terms that you have the other side search their systems for.
In a case about appropriating trade secrets from Waymo, you didn't include the search term Waymo in the e-discovery process.
This may be a function, though. This may be a function, though, of Google just changing the names of their companies just way too much. That at the time, it was some other name of a company, and like they would have used up all their search terms looking at all the names of their companies.
Right. Wasn't there some sort of assertion that we couldn't have them search for Waymo because then we would have been drowned in documentation, or
Booleans, guys? Booleans. Yes. Come on.
What would Google do with more information? Who knows?
Right, exactly. Google bad at parsing information. Wow.
Yeah.
It's been fascinating.
Yeah, you've got all of that, and then Denise, as you had mentioned, Judge Alsip, very experienced, smart judge who's been involved in some major trials between tech titans. I mean, he's, I think, just exasperated by this, by everything. So, I mean, this is just going to be fascinating to see how it plays out. Yeah, there's some doozies for the judge in this case.
So essentially, Waymo is pushing back against the idea that Uber can then ask Waymo about any kind of ephemeral messaging tools that they might use. And Judge Alsip, I'm going to quote from an Ars Technica article written by Cyrus Farvar earlier this week. And this is also the sort of confusion that I was talking about earlier. Judge Alsip wasn't having any of it. This is a direct order, and the public ought to be aware, he said. I can't stand it when Waymo or the other side wants to have it both ways. You have the court's permission to ask not only the practice, but the policies about ephemeral communications when they were at Waymo, and then preserve those records where they obstructed your inquiry because they may be shown to the jury. Now, this is what I talk about confusing language that I wish people would avoid. A few moments, and just like help me parse this sentence, listeners. A few moments later, Judge Alsip was unequivocal, addressing Perlson, quote, "You're trying to blame them for ephemeral, and they get to show if you do it just as badly as you do it," he said.
Yes, which comes across fine in a courtroom and not so much in writing. Yes, indeed. Well, this whole ephemeral communication thing, I think, is one of the most fascinating parts of all this. Of course, we're talking about cutting edge tech companies using cutting edge technology, taking the advice of people like us who get on the internet and say, hey, use secure communications, or I guess secure is not the same as ephemeral, but still communications that may make it harder to see the content of what it is you are communicating. And they're taking that to heart and they're doing it. And now we're seeing, a judge say, hey, if you've got messages that are self-destructing, I think that looks really shady.
They're very selectively doing it. They were using these self-destructing messages when they were out tracking the Waymo cars. And so
that's a whole other side of it was the industrial espionage branch of Uber that apparently exists just to do, quote, market analysis. And it's just literally exfiltrating data apparently from other companies, but allegedly. Sorry, Matt.
Yeah, no. I mean, I think you said it with better emphasis than I would have. So it's not like Uber's using encrypted data that self-destructs in all of their communications. I think that's what the judge was upset about. And so,
Matt, aren't they, in addition to these ephemeral communications, isn't there the secret server where a bunch of things were stored, and that was kind of outside of the normal process that would typically be used for storing corporate data? Wasn't that also a big part the court was disturbed about?
I think that's what the court was upset about. Is like, so you let them search, because you had to, because that's part of the court process, is that they get to search your server. Well, if you have two servers and all of the relevant information is on one, and you let them search the other, then you're not complying with the process of justice, which is discovery and e-discovery and like all of this. So if you're building in dual systems to subvert it, it just looks really bad.
Yeah. The other thing that I think is really interesting about the judge's comments is, typically discovery disputes, every case has a discovery dispute. Some disputes are larger than others, this one being an example of that. But typically juries don't hear about discovery disputes. The jury gets to decide the facts that are relevant to the underlying dispute. But, all the back and forth and the discovery motions and all of that goes out the window when you go to trial. But here, it sounds like Judge Alsip is considering allowing some of this evidence to come in, particularly if there's evidence that the documents were destroyed. I mean, that can be very damning and can be heard by a jury or the fact finder in a case, depending on the circumstances. And it sounds like maybe Judge Alsip is considering letting some of that evidence come in, which could be very hurtful.
Yeah, I think this is a really interesting case in so many ways, and of course, poor Judge Alsip having to parse all of this. It does seem like I wonder what will happen if these federal prosecutors decide they're going to press charges. What will happen to the civil proceedings at that point? Because certainly they seem concerned enough to communicate with the federal judge in the civil case, which is unusual in its own right. And I definitely think, go ahead.
The reason that the AUSA got wind of this was because Judge Alsip informed them that they should look into this. So like the whole thing is very unusual. Yeah. I maybe Mike or you, Denise, could know more, but I don't know of examples where a judge is looking at a trade secrets case and says, hey, attorney's office, like this is something you need to be aware of. So the whole thing looks bad.
I am so legitimately interested. I'm sure that if it's not out there already, that in the next few years, some very cool law professor is going to have a whole class about Uber. In fact, if that already exists out there, listeners, maybe let me know. We can talk about it on the show. But it's just you can make a whole lesson plan for multiple semesters about just what's been going on with Uber in the past year.
But this is the future of self-driving. So what's amazing about all of this is like all this subterfuge and all of this intrigue is all based on like the technology invented by this gentleman, Corey Lewandowski, which literally made the technology possible for both Anthony. I'm sorry, made the technology possible for both Uber and Google. So we're talking about like the pinnacle of the height of technology innovation. So it's just really exciting, and so yeah,
I would watch this movie, is what I'm saying.
Yeah,
for sure.
I think, Mike, too, this whole how is the company communicating and storing data thing. Obviously, Uber was doing things that aren't making the judge very happy here, but I also think that Uber is doing things that probably aren't all that uncommon these days as companies continue to leverage the technologies that are available to them. And, obviously you can't destroy records relating to pending litigation. There are ethical and legal barriers to that. But records destruction policies in general are very common. And I think secured communications in a world where parties are trying to protect trade secrets in a competitive environment are probably very common too. And I think this is just the litigation world that we've arrived at today. And that this case is a window into that. Do you agree?
Oh, I totally agree with that. And yes, I think every company has some sort of document destruction process on their books, or at least I would speculate that most companies do. But of course, as soon as you have a reasonable suspicion or a reasonable belief that a third party may have a claim against you, then you have an obligation the company has an obligation to make sure that documents relevant to that claim are preserved, and that any document destruction processes in place get stopped. So, we'll see what happens here. I mean, this is a big, as we've talked about on the show before, e-discovery is very, very commonplace now. And, it can be easy to get tripped up. Even if a company's acting in good faith, it can sometimes be tricky, and it gets even more interesting when a company may be acting in a nefarious way. So I can't wait for this trial to happen to see ultimately how this plays out, and then write the screenplay after.
Yes.